hope you're doing well. Happy October 22nd, 2025. I'm Daniel Bornstein. It's my pleasure to assist in this webinar. I always start a webinar by congratulating you for making the decision to participate and attend. I can only emphasize that landlord-tenant rules and regulations in California and in Northern California, and particularly in the Bay Area, is a minefield of complexity, and it only gets more and more complex as the years go by. And your job is to be aware of the laws, and when necessary, contact an attorney for assistance. And as you know, I'm open for business. My office now has 7 attorneys. We are in throughout the Bay Area with 2 offices, one in Oakland, one in San Francisco, serving the North Bay, the East Bay, the South Bay, and of course, San Francisco. Today, what we're going to be doing is exposing you to some of the new laws that are coming into effect in 2026, talk about some of the issues that are particularly germane, and we do have some interesting rent increases that are occurring in the Bay Area, specifically in San Francisco, with the emergence of artificial intelligence and all of the ancillary startups that are making San Francisco and the Bay Area wealthier. And we will continue to talk about how we handle disputes throughout the Bay Area in a manner that accomplishes your goal while insulating yourself from litigation if possible. So please, at this point, buckle your seatbelts and let's jump in, and hopefully you'll find this to be a helpful endeavor. Interesting. I know that most of you provide fridges and stoves in your rental units. However, it was never a requirement. Appliances were never a requirement in order to ensure. Click on what? Thank you. Fridges and stoves were never a requirement. However, starting in 2026, you will need to provide a stove and a fridge, and this is new law. For most of you, you will presume this was a requirement, especially in a residential context, but now it's statutorily based. So be advised, I'm going to go into some of the nuances on this, and we will go from there. First of all, refrigerators. They must be in good working order and capable of safely storing food. Stoves must be maintained in good working order and capable of safely generating heat for cooking. Is the stove or refrigerator subject to a recall by a manufacturer or public entity? You're going to have to find that out, because if you have a stove in a rental unit or a fridge in a rental unit that actually has been recalled, then this is not a stove or a fridge that is capable of providing a proper safe functioning, and you must repair or replace it within 30 days of receiving notice of the recall. There are some exemptions, so be advised: permanent and supportive housing, SROs or single room occupancy units, units in a residential hotel, or dwelling units within a housing facility that offers shared or communal kitchen spaces, you don't need to provide the separate stove or fridge. What's going to get complicated is when a tenant elects to have their own fridge. Some tenants come with their own fridge. They have a fridge from a prior place they like, and they want it to be part of their tenancy. You need to make sure you have a mutual agreement in writing at the time of the lease. The tenant will be responsible for maintenance and upkeep of their own appliances. Please note, at any point in time, the tenant can inform you that they no longer wish to keep their own refrigerator, and then you have a 30-day window to provide one to the tenant. the law does not allow the tenant to bring in their own stove. There are many questions abound about a stove. How many burners must a stove have? May it be a simple cooktop, or must it be a freestanding appliance, perhaps with an oven? What size must the refrigerator be? Is it tied to family size? What if a refrigerator is damaged by the tenant? These questions have not been resolved by the statute. There's simply a new rule that you must provide a safe working fridge and stove as part of the tenancy. In my mind, if you provide an appliance and a tenant through their own negligence harms the appliance or harms the stove, I think you can repair it and then thereafter take it off from their security deposit or demand reimbursement. The fight will be whether the stove or fridge malfunctioned because of a problem with the appliance, or whether it was the tenant's own negligent conduct that created the damage to the appliance. Rest assured, every time there's a new law, it takes 10 years for the courts to work out the rules and the interpretation of law, but this is a new law commencing 2026. For most of you, it's a law that may not have as much of an impact because you've always provided a stove and a fridge. Now it's documented, but for the exemptions I've covered. For housing providers, at this point in time, what I would recommend is that if you have multiple units, you want to make sure your fridges are in good working condition. You want to make sure your stoves are in good condition. And when you have a vacancy, make sure that this would be the opportune time to replace a stove, replace a fridge, so that you don't have in the middle of a tenancy a problem with a fridge. And I can only tell you, I have many clients, they get focused on a dispute and they want to win a dispute. And we get into a fight about whether the cause of the failure of the appliance was because of the tenant misconduct or because of the old appliance finally petering out. A client can spend $2,000 in attorney fees fighting over a dispute that doesn't get resolved, or you can buy a fridge for $800. So I want you to always be prudent in your decision making about disputes. We don't want to win a dispute. We want to resolve a dispute as fast and as cheap as possible, taking into account attorney fees, time, and risk. So we want to be smart about your real estate investments. What we want to do is make sure we're compliant with the law, that we're proactive in handling things, and are aware that right now, with appliances, fridge and stove must be provided. Security deposits. I can only tell you that the biggest dispute in landlord-tenant world in California and probably the country is the accounting of a security deposit at the conclusion of a tenancy. And every year gets more complicated. Every year within the last decade, there's been changes to the security deposit rules, and it's a change that adds complexity each year. Last year, it was about photography and the need to take photos at the inception of the tenancy, when the tenancy is over, and after you've done repairs to the unit in order to document the status of the unit in order to do a proper accounting. A couple years before, it was about the amount of a security deposit you can charge. Larger owners, 1 month's rent. Smaller owners, up to 2 months rent. It can get tricky, but that's generally the case. Now, AB 414 changes the security deposit return procedures and addresses an issue that has been a continuing thorn in my side repeatedly. Let's go over and look at these changes. Remember, landlord must return the balance of the security deposit via a single check payable to all adult tenants unless they have a written agreement otherwise. AB 414 also allows for the return method and itemized deductions to be agreed upon in writing at the start of the lease and for the itemized statement to be sent via email. I have so many situations where tenants have left, the owners call me and say, Mr. Bornstein, I have a problem. I don't know where to send the security deposit. They didn't give me a forwarding address. What do I do? Well, if you have an email and you have an agreement, you can send the itemized deductions and the documents through email. Before, I would tell you, send it to their last known address and hopefully they have a forwarding address on that last address. Now there's a way to do it by email, and this is really public policy, understanding that email now is a credible way to engage in communication. The issue that is particularly interesting is where you have 4 adult tenants and one leaves early and disappears to New York, and then 3 years later, the unit is vacant, and you got 3 tenants in the unit. The new rule is that you have to send that check written to all 4 tenants. What does this mean? Well, it's to ensure that all the adult tenants are put on notice of the actual check so that one former tenant doesn't abscond with the check and then not pay the proportionate amount of the security deposit to the other remaining tenants. This creates a solution which puts 4 people on that check, but it also causes a problem. Because if you got 4 people on a check, you're going to need to have 4 people sign off on that check in order to be able to actually deposit the check or cash the check. And that creates a organizational nightmare for these tenants who may be in different locations. But you know what? That's a problem that we'll address in the future. That's a tenant problem, not a landlord problem. The most important thing right now is that landlords must return the balance of the security deposit by a single check payable to all adult tenants unless they have an agreement otherwise. Get that written agreement otherwise, make sure everybody signs it, and you have a document confirming how you're going to handle the security deposit accounting. Remember, you can send the itemized statement via email as long as it's all agreed in writing. The tenants can agree on the return method at any point during the tenancy, even at the beginning of the lease. The law was created to simplify the process for renters and provide clarity for landlords when multiple tenants are on a lease, especially in situations where roommates disagree or are hard to reach. I do believe that this will help resolve some of the complexity, but it will also create issues into the future. Again, I don't write the laws, I try to interpret them, and every year it gets more and more complex, and we want to make sure that we do things correctly so we're not in violation of the law. I can't tell you how many situations I have with revolving roommates and the initial tenants are no longer to be found, but they were the ones that provided the initial security deposit. Under the current law, you're going to need to deal with that in issuing a check to all people. And if the tenants object because they can't find that initial tenant, well, you're going to have to say, go find them and get an agreement otherwise. Until that time, I'm writing the check to the 4 people who gave me the money. I have provided a cheat sheet for you so you can take a look at this. It takes effect January 1st, 2026. You've got more flexibility in how the security deposit is returned and how itemized statements are delivered. And here, if you can get an agreement, perfect. If you can get the agreement at the inception of the tenancy, perfect. If you've got multiple defendants, remember, we've got to make sure that you list all the adults on the lease. But of course, you can only send one check at one time, so you'd have to send it to one of them. And the deposits or rents are paid electronically. Refunds must also be by electronic unless both parties agree otherwise. I don't make the law, I'm just providing you information so that you understand the nuances. The most likely dispute you're going to have as a owner or a housing provider is a security deposit dispute. I cannot tell you how complex it's gotten since 30 years ago when I started. 21 days to return a security deposit, no right to pre-move out inspection, no multiple visits to the unit, no photographs, none of this. What has happened in the security deposit law is analogous to what is happening in all aspects of landlord-tenant law. Complexity reigns. You got to almost have an attorney to handle the security deposit accounting. Your head will spin. If any of you want documentation on security deposit accounting, email me. I'm happy to send you my documentation. My email is daniel@bornstein.law. As you know, I'm always about education. It's my pleasure and privilege to educate you about the law. I can only tell you that I much prefer being proactive with you and educating you about the law as opposed to informing you about how you have failed and lack of compliance with the law. That creates misery. Proactive information provides you best practice so that you insulate yourself from lawsuits. Oops. New rule. Remember, AB 246. We're not going to evict or attempt to evict a tenant for non-payment of rent when there's a verified interruption of their Social Security benefits. This law makes good sense, except for the risk of an interruption in Social Security benefits is not shared by the tenant and you, but now the tenant's interruption in their Social Security benefits is going to cause you to have to delay in the eviction. And this has to be a verified interruption in their Social Security benefits. And this is something that is attempting to keep people in their housing despite an interruption in Social Security benefit delay. I can only tell you that the laws are being constructed in order to create stability in housing, and the risk of interruption, which one would think would be shared by all parties, is on the owner. So if you know someone who is going to be dependent upon their Social Security payments to pay rent, and there's a delay in Social Security benefits, before contacting my office, please make sure if the tenant has informed you that there's an interruption that's verified. We don't want to start the eviction process. It will be a defense to the eviction that the delay in Social Security benefits was at the heart of their failure to pay the rent. In particular, if a tenant can prove the federal government is at fault for a delay that prevents them from paying rent, the court may pause the eviction proceedings. Again, the delay must not be caused by the tenant. Remember, this is only for non-payment of rent. If the tenant has a delay in Social Security payment, but they're engaged in nuisance or illegal conduct, that's not going to be a defense. And again, the tenant's rent is not waived. It's merely a delay in the eviction process. You're still entitled to demand the rent. You're gonna need to wait 14 days to get that past due rent. And the delay of Social Security benefit as one that delays payments 3 or more calendar days beyond the scheduled date. Now, many of you are thinking, how am I gonna ever know if there is an actual delay in a tenant's Social Security payment? Well, the tenant is likely to inform you once you serve a 3-day notice, or the tenant's attorney is likely to inform you of this, or you may know it because of the news. And one of the things that I would tell you is that as a owner of rental property, your job is to stay informed of current events, stay informed of new laws that arise. And I'm talking to you folks who have self-selected into this webinar. You're making the decision to keep yourself abreast of this. I stay actively involved in learning in order that I can disseminate information to you. If you're on my e-blast list, perfect, because I'm sending updates about new laws or what's going on when I see something that I believe is germane and appropriate for you to know. Please invite your friends, your colleagues, and other rental property owners to participate in my email blast and become a recipient, so they do also gain this knowledge, and there won't be further people calling me after the fact and griping that they didn't know about the new law. Your job as a rental property owner is to stay informed of the new laws and get yourself to an attorney when you have a need for one. AB 325, this is very interesting. As we become more adept at using technology, algorithms, and data to set rent levels, the community of politicians and housing advocates try to stamp this out. And the rule is, you are no longer to use collusive use of pricing for setting rent levels. There was a group of housing providers, large, who were using algorithms and data to set what would be rent levels in particular areas. And the new law came into effect that says you're not allowed to use this because it creates an unfair advantage. And therefore, if you do use these services, you can be sued. That doesn't mean you can't independently do a assessment of what you believe to be market rate for your unit. Go to Craigslist, go to other places and get a sense of what market rate is, but you can't use pricing algorithms to set rent levels. And this is something that can be very, very frustrating for larger housing providers who want to ensure that they're setting rents at a market rate that makes sense. Typically, I would think information should be something we welcome, but politicians and housing advocates on behalf of tenants have banded together and made a determination and a new law saying that you're not to use these pricing algorithms or you can face liability. Well, we are all in a new world in this country, and I can only say that I am watching, stunned, shocked, and amazed at some of the things that are happening in our government and throughout our society. Right now, we are witnessing a continued shutdown, and it is racking nerves for housing providers, especially those who are relying on subsidized rents. If we have tenants who are federal employees and the government is shut down and they rely on their monthly payment in order to actually effectuate a timely payment of rent, well, you will suffer. Also, please note, if you are a participant in Section 8 or housing authority payments, we shall see whether there is going to be a delay in housing authority subsidized payments over time as this shutdown continues. I am confident that we will learn in the news whether or not our housing providers, such as the San Francisco Housing Association, the Oakland Section 8 program, the Marin program, runs out of money as a result of this shutdown. My hope is that some sort of resolution occurs within our political environment such that the shutdown is no longer and we don't have a risk of loss of salaries for our federal employees and or subsidized payments from the housing authorities of the different city and county entities. January 1st, 2026, AB 1414, landlords must allow tenants to opt out of landlord-mandated internet, cellular, or bulk billing plans. Let me say that again. effective January 1st, 2026, landlords must allow tenants to opt out of landlord mandated internet, cellular, or bulk billing plans. Tenants will no longer be compelled to pay for a service or an internet speed they don't need or pay a provider that they don't choose. Let me say that again. Many of you who have been pitched by internet or cellular companies offering a bulk service and a benefit for providing service to your building, tenants will no longer be compelled to pay for the service that they don't need, that they don't choose. Loss of bulk discounts are going to arise when fewer tenants are on board. There is now an administrative burden for you of managing opt-ins and opt-outs. There are maybe existing contract liabilities under long-term ISP agreements. And now we have a heightened risk of tenant disputes surrounding charges imposed. We had thought that negotiating bulk plans for tenants creates an opportunity for tenants to have a better price point for service. However, the imposition of it is something that AB 1414 has now, effective January 1st, said you cannot force a tenant to opt in. They have the right to opt out if they don't want to participate in the plan. Be advised, for those of you who have bulk plans that are in these larger buildings, you've got to make sure that before January 1st, you have the necessary documentation in place to allow tenants to opt out. If you have any questions, by all means, let me know. Now, I am always, when I give a seminar, interested in making sure that you have a review of the termination process. Many people don't realize that this termination chart really is a reflection of how we go about terminating a tenancy. And previously, when people would call me and say, Mr. Bornstein, how long will an unlawful detainer action last? I would say 8 to 12 weeks. With new rules, new laws, post-COVID delay, and the unfortunate bureaucracy of the court system, I'm now telling people it's 120 days from the date of filing the lawsuit. So for example, if you call me up and you say, Mr. Bornstein, I want to do an owner move-in termination and my tenant has lived in the premises over a year, I will tell you it's a 60-day notice. And you will see on the right-hand side of the chart, 60 days. Well, if we serve the termination notice November 1st and the notice expires the end of December, that's 60 days. If the tenant moves out, we're thrilled, matter's over. If the tenant doesn't move out, then we have to file what's called an unlawful detainer action. An unlawful detainer action is the industry trade word for an eviction action. The tenant is unlawfully detaining possession of the premises. That is where it will take 120 days to work itself through the court system. There are delays in service. There are pretrial motions. There's the delay, and much of the delay often is, how can I get this person served as quickly as possible? A tenant who hasn't paid the rent for 3 months, and then you serve a 3-day notice to pay rent or quit, and the tenant doesn't pay the rent, and then you file the lawsuit. Do you think that tenant is going to open the door when you knock on it to serve them the lawsuit? No. They know that their tenancy is coming to an end and that a lawsuit is likely to be filed. And that delay in service is what can take another 4 weeks to get itself into the case. This chart provides you the chronology of the eviction process. And for those of you who work with me, I always like to have you have this chart so that if we are working together on a case, you can always say, Mr. Bornstein, what's going on with my case? And I can say to you, the tenant filed an answer. We have filed a memorandum to set the case for trial, and we're waiting for a trial date and settlement conference. And right now, just for your knowledge, in San Francisco, if I have filed a request to set a case for trial during the month of October, do you know what date they're setting for trials now? Not in November, not in December, but in January. So we're waiting 10 weeks to simply get the settlement conference and the trial. It used to be 20 days. Now it's 10 weeks. So everything is delayed. And that's why we want to avoid litigation if we can, but we never know whether that's going to be possible or not. I want to mention this because I'm a business guy. I don't like disputes. I like to resolve disputes. I like to have you cash flowing out of your real estate investments. And I want to always, if you have a cash flow problem because you have a tenant who's not paying the rent, or you have a community problem where a tenant is so disruptive that other people are leaving the building, I want to solve that problem. Right now, though, what we have, which is phenomenal after waiting 5 years, we have increase in rents, especially in San Francisco. San Francisco is the one area in the country where rents are increasing rapidly. It's directly related to our tech boom, artificial intelligence. People are coming back to work and they're creating a greater urgency, a greater market for these rental units. So what do? Well, tricky. Let's talk. We know if you own a multi-unit property in San Francisco, your property is going to be subject likely to rent control in San Francisco and just cause eviction rules in San Francisco. If you own a multi-unit property in Oakland, same. In Berkeley, same. If you own a multi-unit property in San Mateo, you're going to be subject likely to state rent control and state just cause eviction rules. So we're always aware of the different rules. And what do we do? What do we know throughout California is the rule? We know that when you have a vacancy, you can set the rent to market rate. Until you have a vacancy, you're subject to typically rent regulation unless you're one of those people who have single family home or a condominium unit. Those are typically not subject to rent regulation, depending upon a number of factors. But why I bring this up is that if you own a multi-unit property and you've got a fourplex and you've got a tenant who's $2,000 below market, we negotiate deals for people to voluntarily vacate. Each situation is different, but anytime you can negotiate someone to voluntarily vacate a unit, the upside is quite beneficial. A simple metric is as follows. For every $1,000 differential in rent you can get for a unit, the building increases in value at least $100,000. So if you have a tenant paying $1,500 a month, but the market value of that unit is $2,500, when that tenant vacates and you rent the place out for $2,500 a month, you've increased the value of your building $100,000. That's the easy metric. So this means that there is a value in negotiating voluntary agreements, both ethically, properly, compliant with the law. Every city that I'm mentioning is going to have different rules. Alameda has a different set of rules. Richmond, California has a different set of rules. Berkeley has a different set of rules. San Francisco has a different set of rules. Oakland has a different set of rules. When I first started 30 years ago, there were 3 rent ordinances and 3 rules: Berkeley, Oakland, San Francisco. Now in the Bay Area, there are 16 different rent ordinances. Buyout agreements are regulated per an ordinance. and I'm happy to help you understand it. But I want you to understand that generally, I believe that you are well served by seeing the possibility of negotiating a voluntary move out when the need arises. And this is often when you decide to sell a property and you want to sell a property vacant. It can arise where you have a tenant who is not paying the rent, and instead of going forward with an expensive non-payment rent eviction, you can negotiate a voluntary move out from the premises. If you're looking to move into the property, and instead of doing an owner move-in termination, which can be very expensive, you want to negotiate a voluntary move out, I'm happy to provide the guidance to do this. There are ways to leverage the discussion, such as potentially raising the rent on a condominium unit, waiting 6 weeks, and then having a dialogue. I always recommend, as long as you have good communication skills and don't have too much acrimony between yourself and the tenant, to negotiate the deal between yourselves. I stay in the background and I prepare the agreement. I can coach you and consult with you on how to do the negotiation. I prepare the agreement. There are some circumstances where I will actually step in and negotiate the agreement. That's typically where you can't have a positive relationship and communication with your tenant because your history of dysfunction and fighting is such that you need a third party to assist. The reason why I don't want to be typically the person doing the negotiation is because if I do the negotiation, the tenant may get an attorney. And if the tenant gets an attorney, a tenant attorney, they may know the value of the vacancy more than the tenant, and that will increase the cost of the buyout. Another question is, when are you going to pay the tenant? So I have old school people who say, I'm not going to pay the tenant until they give me the keys. I like it a little bit different. I like to give a little bit of the money when they sign the agreement or after the right of rescission has lapsed, a little bit, and the bulk of the money when they vacate. The reason why I like to give a little bit of the money at the time they sign the agreement or after the rescission period is because they see that you're committed to complying with the agreement, and psychologically they start to take the necessary steps to transition from the premises. Also, some tenants, because they're without savings, they need a little bit of the money to put a down payment on another unit, get that security deposit in first month's rent. So sometimes you have to facilitate the transition by fronting some of the money. I have found that that is usually the best use of resources. And these buyout agreements to avoid litigation is a great choice. And I can only tell you that if you have property in San Francisco, it's another set of rules. If you have property in Berkeley, it's another set of rules. If you have property in Oakland, another set of rules. In Walnut Creek, it will be a generic buyout agreement, but I'm happy in a half hour of conversation, I can get you educated to start the dialogue. And if you can avoid going to court and can reach a voluntary agreement with the tenant vacating, you're typically well ahead of the game, because the cost of an attorney at court can become prohibitive, and a buyout, at least you're getting clarity, you're getting the vacancy on a fixed price. And remember, another important point about a buyout agreement, I'm not just giving a tenant money to vacate the premises. I'm giving a tenant money to vacate the premises and give up all claims arising out of the tenancy. So when they leave, there's no residue, there's no risk. They've signed a release of claims. For many of you, where we have the emergence of mold claims, I've got a mold problem in my building, I've got a respiratory illness. If you negotiate a deal for the tenant to move out and they sign a buyout agreement and they give up claims and waive all claims arising out of their tenancy, even those claims they don't know about, you've solved that mold liability issue. And we all know right now that it's so expensive to get insurance, and the insurance that's being offered to housing providers is not as attractive as it was before. There are exemptions, there's habitability exemptions, there's mold exemptions, there's asbestos exemptions, there's lead exemptions, and so you're paying more money for less insurance. And that means that if I can get a voluntary move out with people vacating without having to get into court, and you've got a properly drafted buyout agreement, you're good to go. You've got the vacancy, clean up your unit, put in a working stove and a working fridge, and get maximum rent and get your cash flow going for this property. I'm always about that. I don't like disputes. I want to resolve them. I want you to build a nest egg in choosing to be part of the housing provider industry, but you've got to recognize it is so full of risk, liability, that an imprudent decision made in haste without knowledge of the law will create liability for yourself that I can't undo. I can only try to minimize. And if you don't have insurance, you're going to be bleeding money, and I don't have easy solutions for you. I pride myself on being direct, transparent, and blunt. And sometimes I have conversations with clients and I simply say, you're in a terrible situation and I can help you, but you're going to be in a situation where you're going to be writing a check, and I don't have an easy solution. I will try to have that check written for as little as possible. So I am always available to speak with you. If you want to schedule a meeting, just email me. I have in last year in 2024, I think I had between 700 and 800 half-hour meetings. I'm always available to assist. If I think we need more time, I'll let you know. But the most important thing is when you're confronting a difficult situation, an allegation of mold, an allegation of nuisance, people complaining about smoking in another unit, an individual not able to sleep because of intermittent partying that's going on in another unit, a tenant who has threatened violence. When you have these type of situations, you need to act, and I'm happy to give you guidance. The law keeps changing, the laws keep getting complex, and it's my pleasure to be a part of the dialogue and help you make good decisions about your real estate investment. Again, I'm Daniel Bornstein. We are privileged to be able to help you out. And I can only say that 2026, hopefully the economy in the Bay Area continues to improve, and hopefully the politics of our country transitions to a place of more safety and security so that we can all be comfortable in how we look at the future. And it's my hope and my goal to continue to educate you. If you aren't receiving my e-blast, by all means, send me an email and I'll get you on our list so that you are part of our social media team and we continue to engage successfully with you so we can serve you throughout 2026 and in the future. Thank you very much for your attention. This is Daniel Bornstein. Have a great rest of the day. And if you do have some questions, by all means, email me. Again, it's my pleasure to have helped you out today. Thank you.